What's going on YouTube? Listen up, young elder gang, this is Joe Blow, at you with another banger. Please make sure you like, subscribe and share this video fam. I hope this video get at least 100,000 likes. In this video, you will find history, definitions, scripture, information, and best of all, what we Americans have been deprived of from the beginning, the truth. Keep in mind this content used in this video is intended for entertainment, educational, and informational purposes only. The information provided on this video is not to be construed as legal advice. We are not legal attorneys. For legal advice, please seek out a licensed legal advisor or attorney. We will give you the total truth as we best understand it today. Be sure to hit that like button, young elder gang. Hit that subscribe button if you're new to the channel. Hit that bell and don't forget to check back with us every day for new content. This is Young Elders Law School, 4th day. If you haven't checked out the first, second, and the third day, check out the other 3 days just below this video on the video side. Alright, let's get started. How to file an appeal. The process for filing an appeal in law typically involves the following steps. Determine if you can appeal. Calculate the time limit. File a notice of appeal. Pay the filing fee. Serve the notice of appeal. Order transcripts. Determine what to file with your brief. Write your brief. Some other things to consider when filing an appeal include additional information. Whether you need to provide additional information to the appeals court. Cost bond. Whether you need to file a cost bond. Staying execution. Whether you want to stay execution of the judgment. Statement of evidence. Whether you need to file a statement of evidence and points on appeal. An appeal is a request to a higher court to review and change the decision of a lower court. The reasons for the appeal, such as procedural errors or misinterpretation of law, need to be legally sound. In an appeal, there is no jury, and lawyers do not present witnesses or other forms of evidence. Instead, the court accepts the facts revealed in the trial court, unless a factual finding disputes the weight of the evidence. All pleadings/motions/requests may be filed with the Appeals Division by mail, fax, or email. The Appeals Division fax number is 225-342-8058, and its email address is dscs.appeals@ella.gov. The Appeals Division's fax and email are available 24 hours a day. What is a petition for rehearing en banc? In federal court, a party that loses its appeal may petition for rehearing en banc hearing. An en banc hearing means that all or many of the appellate judges from that court will hear your case. Courts are not obligated to accept a petition for rehearing en banc, and by and large very few of the petitions are accepted. They are most likely to take up the petition if the case raises important issues of unsettled law, or if there are contradictory interpretations of a law that should be resolved. A petition for rehearing en banc is a request to have a court reconsider its decision by having the full court or an en banc panel review the case. The term en banc is French for on the bench, and refers to a procedure where all judges of a court hear a case. A petition for rehearing en banc is appropriate when there is a split within the circuit on a legal issue. The case involves a question of exceptional importance. The merits panel failed to follow existing decisions of the U.S. Supreme Court or Federal Circuit precedent. The merits panel followed Federal Circuit precedent that the petitioning party seeks to have overruled. Courts rarely rehear cases or undertake en banc review. A request for rehearing en banc must be filed at the same time as a petition for panel rehearing. A writ of certiorari to the Supreme Court is a request that the United States Supreme Court consider a case. The U.S. Supreme Court has authority to take up appeals of lower court decisions, but is not obligated to hear those decisions. To ask the Supreme Court to hear a case, a party files a writ of certiorari or a cert petition. The Supreme Court agrees to hear very few of these cases. Most of the cases the Supreme Court takes up involve important issues of federal law for which there is not settled law. A writ of certiorari to the Supreme Court is a formal request asking the Supreme Court to review a decision made by a lower court, essentially asking the Supreme Court to be more fully informed about the case and potentially hear arguments on its merits. It is the primary means for a party to petition the Supreme Court to review a lower court decision, and the court is not obligated to grant a writ of certiorari, usually only doing so if the case presents significant legal issues or national importance. Key points about a writ of certiorari. Meaning of certiorari: the word certiorari comes from Latin and means to be more fully informed. How to request. A party who wants the Supreme Court to review a case files a petition for a writ of certiorari. Supreme Court discretion. The Supreme Court is not required to accept every petition for a writ of certiorari. and usually only hears cases with significant legal questions or national impact. Granting cert. If the Supreme Court decides to review a case, it is said to have granted certiorari. The primary means to petition the court for review is to ask it to grant a writ of certiorari. This is a request that the Supreme Court order a lower court to send up the record of the case for review. A written statement of facts confirmed by the oath of the party making it. An affidavit is a written statement that is signed under oath or affirmation and used as evidence in legal proceedings. The person who signs the affidavit is called the affiant. A notary or other authorized official verifies the affidavit. Affidavits are commonly used in legal proceedings when live testimony isn't possible. They can be used in a variety of legal cases, including bankruptcy. Affidavits can be used in bankruptcy cases. Family law. Affidavits can be used in family law cases, such as divorce proceedings. For example, an affidavit of residence can be used to show where someone lives for employment purposes, or so their children can attend school in their district. Name change. An affidavit of name change can be used to show that someone changed their name after a divorce or marriage. Support. An affidavit can be used to show that a foreign visa applicant has enough financial support to enter the country. Financial affidavits. An affidavit can be used to certify financial information for family law matters, such as a divorce or child support hearing. Affidavits can also be used outside of the courtroom. For example, someone might use an affidavit in a business context to state the circumstances of a financial transaction. An affidavit is a written statement voluntarily made by an affiant or deponent under an oath or affirmation, which is administered by a person who is authorized to do so by law. Affidavits can occur any time a formal promise is made, and they are often used as a form of documentation tied to a specific person in the proceedings. They are often used in court to serve as evidence toward a singular side in a dispute, or to affirm a claim that someone is making. A sworn statement in writing made especially under oath or on affirmation before an authorized magistrate or officer compare deposition, examination. I, Joe Blow, having been first duly sworn, provide this affidavit in support of Jane Blow, enter applicant's name, and state the following. I am unrelated to the applicant by blood or marriage, and not currently living in the same household with applicant. A legal affidavit must be signed by the person making the statement to be considered legally binding. In many cases, the affiant must also sign the document in front of a witness. That witness is often the notary public, but they could be anyone willing to swear the signature is authentic. A bench trial is a trial by judge, as opposed to a trial by jury. The term applies most appropriately to any administrative hearing in relation to a summary offense to distinguish the type of trial. Many legal systems use bench trials for most or all cases or for certain types of cases. A bench trial is a legal proceeding where a judge acts as the sole decision maker instead of a jury. Process: the judge listens to both sides, present evidence and arguments, and then decides the facts of the case and applies the law. Common use bench trials are often used in civil cases and courts of limited jurisdiction. When to use: parties may choose a bench trial over a jury trial for a variety of reasons, including cost and efficiency. For example, bench trials can be conducted more effectively in socially distant settings or over Zoom. When to request: in the federal court system, a defendant can waive a jury trial in writing, but the government must agree and the court must approve. In each state, the circumstances in which bench trials are allowed vary. Judges in bench trials are often assumed to be better able to focus on facts rather than a client's record, observe violent or gruesome facts without emotional distress, discount negative news coverage and publicity, a trial without a jury where a judge decides the facts. Courts and counsel often prefer bench trials, which can be more efficient and easier to navigate than jury trials, in part because the judge both acts as the finder of fact and rules on matters of law and procedure. He opted for a bench trial believing the judge would understand the complexities of his case. Here are some of the disadvantages to bringing the case before a judge and not a jury. One person decides. The judge knows all the evidence. The judge will follow the rules and pressure to convict. Know and understand your audience, including the judge and any law clerks involved, by conducting research on their background, recent cases, and experiences of other lawyers. Be prepared to be flexible during a bench trial, as judges may have different approaches and leniency with rules of evidence. Binding precedent is a legal rule or principle, articulated by an appellate court that must be followed by lower courts within its jurisdiction. Essentially, once an appellate court reviews a case, it will deliver a written opinion. A binding contract is any agreement that's legally enforceable. That means if you sign a binding contract and don't fulfill your end of the bargain, the other party can take you to court. You might encounter binding contracts frequently, whether you're signing a rental lease agreement or just bought a car. Precedent refers to a court decision that is considered an authority for deciding subsequent cases involving identical or similar facts or similar legal issues. Precedent is incorporated into the doctrine of stare decisis and requires courts to apply the law in the same manner to cases with the same facts. Roe v. Wade. This is one you're likely very familiar with even if you didn't know exactly what a legal precedent was. Roe v. Wade was a 1973 U.S. Supreme Court case that looked at a woman's right to have an abortion or not. The case itself was a lawsuit over denied abortions. Precedent is a principle or rule established in a legal case that becomes authoritative to a court or other tribunal when deciding subsequent cases with similar legal issues or facts. A prior court decision that must be followed without a compelling reason. A brief is a written legal document used in various legal adversarial systems that is presented to a court arguing why one party to a particular case should prevail. In England and Wales, the phrase refers to the papers given to a barrister when they are instructed. A written statement submitted by each side's lawyer in a case. A legal brief is a written argument that a lawyer submits to a court to convince the judge to rule in favor of their client. Briefs can take different forms depending on the case, such as a memorandum of law, an appellate brief, or a mediation statement. Here are some things to know about legal briefs. Purpose. The purpose of a brief is to persuade the court to rule in favor of the lawyer's client. Content. A brief includes a statement of facts and law that supports the lawyer's position on the case. Preparation. Lawyers prepare briefs to highlight and clarify information or to provide legal comparisons. Amicus briefs. In high-profile cases, third parties with a strong interest in the outcome may submit amicus briefs. Briefing a case. For law students, briefing a case means writing a summary of the case, including the parties involved, the issues, the judge's decision, and an analysis of which arguments succeeded. Word origin. The word brief comes from the French word brevi, which is Latin for summary or short document. A case brief is a short summary of the main points of the decision. The key is short. Do not rewrite the opinion but rather distill it down to its essence. After all the briefs are filed and the Court of Appeal has had time to review them, the court will contact the parties to ask if they want to participate in oral arguments. All parties who file a brief that the Court of Appeal accepts will have an opportunity to make an oral argument. A legal dispute or claim brought to court. A pleading filed by the defendant in a civil case to respond to the plaintiff's claims. A lawsuit is a proceeding by one or more parties against one or more parties in a civil court of law. The archaic term suit in law is found in only a small number of laws still in effect today. Tort complaints, malpractice, birth injury, accident, product liability, strict liability, legal malpractice, slip and fall. Breach of covenant not to compete, employment law. Property damage, racial discrimination, sexual battery, unwanted touching by a doctor. A lawsuit is a legal action brought by one party against another in a court of law to resolve a dispute. It is a way to seek justice and compensation for injuries or losses caused by another person or company. The plaintiff will win the case. Then, the plaintiff can enforce the judgment against you. This can mean getting money from you by garnishing your paycheck or putting a lien on your house or car. 4. A judgment against you can also show up on your credit report. A civil action begins when a party to a dispute files a complaint and pays a filing fee required by statute. A plaintiff who is unable to pay the fee may file a request to proceed in forma pauperis. If you're being sued, you'll receive official court papers. If you are being sued, you'll receive at least 2 documents. One is called a summons and the other a complaint. These documents are typically handed to you or might be left with someone 18 years or older at your home, work, or mailing address. Money awarded by a court to a person injured by another person. In law, damages are a sum of money that a court awards to a person who has suffered an injury or loss due to the negligence or unlawful act of another party. The goal of damages is to compensate the injured party and make them whole again. Damages can be awarded in a variety of situations, including breach of contract. A court may order damages if a party breaches a duty under a contract. Tort. A court may order damages if a party commits a tort, which is a wrong or breach of duty. Personal injury. A court may order damages if a defendant is liable for causing harm to an injured party in a personal injury case. There are different types of damages, including Compensatory damages. These damages are based on the actual losses of the injured party. Punitive damages. These damages are intended to punish the wrongdoer. They are not commonly awarded and the plaintiff must meet a high burden to recover them. Economic damages. These damages are costs related to the injury that can be documented with bills, receipts, and other documentation. Damages are imposed if the court finds that a party breached a duty under contract or violated some right. The sum of money included in the damages can be compensatory damages that are calculated based on the harmed party's actual losses, or punitive damages intended to punish the wrongdoer. At common law, damages are a remedy in the form of a monetary award to be paid to a claimant as compensation for loss or injury. To warrant the award, the claimant must show that a breach of duty has caused foreseeable loss, a loss or harm caused by injury to one's person or property. 1. Plural, payment in money ordered by a court for loss or injury. Collected damages for his broken arm in the accident claim. Primary tabs. In tort law, actual damages, also known as compensatory damages, are damages awarded by a court equivalent to the loss a party suffered. If a party's right was technically violated but they suffered no harm or losses, a court may instead grant nominal damages. When a defendant fails to appear and answer the summons and complaint. In finance, default is failure to meet the legal obligations of a loan. For example, when a home buyer fails to make a mortgage payment, or when a corporation or government fails to pay a bond which has reached maturity. In law, a default is when someone fails to fulfill an obligation, such as a legal requirement or a contractual obligation. Defaults can occur in many different situations, including: in a lawsuit, when a defendant fails to respond to a complaint or appear in court, the plaintiff can ask the judge to decide the case without the defendant's input. This is called a default judgment. In a contract, when a party fails to comply with the terms of a contract, such as by not making mortgage payments, this can lead to the creditor taking action, such as foreclosure. In a divorce, when a party fails to respond to a divorce petition, the divorce process can still take at least 6 months to complete. To avoid a default judgment, a defendant should respond to the lawsuit promptly. If a default judgment has already been awarded, the defendant can file a motion to have it nullified. Primary tabs. A default judgment, also known as judgment by default, is a ruling granted by a judge or court in favor of a plaintiff in the event that the defendant in a legal case fails to respond to a court summons or does not appear in court. A person, usually a parent, appointed by the court to represent a child or unborn person in a court case. A guardian ad litem, GAL, is a person appointed by a court to represent the best interests of someone who is unable to protect their own rights. Role: a GAL acts as a fact finder for the court, investigating and making recommendations based on what is in the ward's best interests. When appointed, a GAL is often appointed in cases involving child custody, child support, adoption, divorce, emancipation, or visitation rights. Who can be a GAL? A GAL can be an attorney, volunteer, or employee of a county program. How they operate: a GAL's duties include interviewing the ward, parents, and other people involved in the ward's care, reviewing medical care, and seeking the ward's opinion. How they are regulated: qualifications, training, compensation, and duties for a GAL vary by state and local laws. A guardian ad litem, GAL, is a neutral person the court appoints to investigate what solutions would be in the best interests of a child. Here, we are talking about a GAL in a divorce or parental rights and responsibilities case. A court's authority to hear cases and make legal decisions. Jurisdiction is the power of a court or government agency to make decisions and issue orders, or the territory within which they can exercise that power. It can also refer to the authority of a sovereign power to govern or legislate. Jurisdiction can be important in determining which court will hear a case, which law enforcement agency can get involved, and the final outcome of a case. Factors that can affect jurisdiction include: location, where the case takes place, such as in which state; subject matter, the type of case, such as cases involving estates in probate court; individual, the identity of the individual involved, such as whether they are a juvenile who can only be tried in juvenile court. The word jurisdiction comes from the Latin jurisdiction, which literally means a saying of law. In law, subject matter refers to the topic or issue being discussed in a legal context, or the legal rights presented for consideration. In a court case, the subject matter is the dispute between the parties, such as the terms of a contract and whether they were violated. Patentable subject matter, the types of inventions that can be patented, such as a new machine or process. Subject matter jurisdiction, the power of a court to hear and decide cases of a particular type. For example, a bankruptcy court can only hear bankruptcy cases. Subject matter jurisdiction is one of two types of jurisdiction, the other being personal jurisdiction. Personal jurisdiction governs where the parties may be heard, while subject matter jurisdiction governs what the court can hear. A court must have jurisdiction to enter a valid judgment on a claim. If a court does not have jurisdiction, the plaintiff may need to refile the case in a court that does. Subject matter refers to the topic or issue that is being discussed or disputed. It can also refer to something that is being claimed as a right or duty. In some cases, it may be related to something that can be patented. I found the film's subject matter to be quite disturbing. She disapproves of the artist's choice of subject matter. These examples are programmatically compiled from various online sources to illustrate current usage of the word subject matter. When the issue at the center of a case is not live, in law, a moot issue or case is one that has lost its practical significance because the underlying controversy has been resolved. A court may dismiss a case as moot when it would be futile to render a judgment because no dispute exists. The word moot comes from the Old English word motion, which means to meet with, to discuss, or to argue. Moot can also refer to a specialized application of persuasive advocacy that is a part of legal education. This is called mooting, and involves presenting arguments in a simulated court setting. Mooting helps law students build confidence, refine their public speaking skills, and expand their professional network. Here are some tips for mooting. Engage with the judge by maintaining eye contact, speaking at an appropriate volume and pace, and responding directly to questions. Apply propositions of law to the facts to argue for the desired result. Be familiar with the moot problem and be able to refer to relevant paragraphs. Use authority in your submissions and know what principle a given case stands for. Manage your time and be able to adjust your submissions based on the judge's intervention. In law, an issue or case being moot means that it has lost its practical significance because the underlying controversy has been resolved one way or another. When a higher court sends a case back to a lower court for further action. In law, remand means to send something back or to return. It can refer to sending a case back to a lower court. When a higher court reverses a lower court's decision, it will often remand the case back to the lower court for reconsideration. The higher court will explain to the lower court how it fell short, such as by not instructing the jury properly. Imprisoning a prisoner, a judge may remand an accused criminal into custody until their trial. This is often done when the accused has a criminal record or has been charged with serious crimes. Sending a case to a federal agency. A case can be remanded to a federal agency for reconsideration in disputes over regulations or administrative decisions. The word remand comes from the medieval Latin word remandare, which means to send back word. To remand something means to send it back or to return. The usual contexts in which this word is encountered are in the reversal of an appellate decision and regarding the custody of a prisoner. A prisoner is said to be remanded when they are sent back into custody to await trial. If a person is remanded on bail, they are told to return to the court at a later date, when their trial will take place. Carter was remanded in custody for 7 days. The legal system's Latin roots contribute to the confusion surrounding its terminology. However, many lawyers are adopting a plain English style to help reduce